Queen City News is your local election headquarters. 2 lawsuits over a new North Carolina law surrounding same-day registration can move forward. People who register to vote and cast their ballot at the same time could have their ballot thrown out if election officials send them a piece of mail that can't be delivered. Now, before this change, election officials had to send 2 pieces of mail that couldn't be delivered before striking a ballot.
Queen City News Chief Legal Analyst Khalif Rhodes joins us now to take a deeper dive into this. Khalif, election season, there always seems to be something, and now a new layer.
I first thought it was me. I moved to Charlotte in 2010, right? And ironically, I was like, well, what else happened that year? 2010 was the first time since 1870 that both House and Senate in North Carolina was controlled by the GOP. And since that time, there have been a number of changes that have been challenged to the Supreme Court, to our state Supreme Court, and the U.S. Supreme Court for attempting to change voting laws. And so, first of all, I can say it wasn't me. But I know that if you're talking elections, you're talking maps, or you're talking voting changes, these changes were 2 critical changes, specifically the way they look at same-day registration. The past law was that there needed to be 2 attempts to deliver mail, and they come back undeliverable. The change was that it could be 1 piece of mail that come back undeliverable, then your vote could be taken away. The judge in this case believed that that was a stretch. He also stated in his previous opinion that he thought it was unconstitutional. And for those reasons, that's why their claim could continue. Typically, I talk about 2 things. I talk about standing. If you don't have standing, you can't get a case, right? Sure. Your case should be dismissed because you're not even a victim of this type of action. Something else that's extremely important is called mootness. If your case no longer matters, you may have standing, but whatever you're attempting to sue for, it isn't an issue anymore. I was mad that my wall was white. You went and painted it black. Issue's done. The state elected officials are saying it's moot because state election officials sit instructions to say, hey, here is the process, here's the procedures you should follow. The judge said that's not enough because those type of rules aren't statutes. They're not laws. You can change those rules any day. So obviously the timing of this is important as we get to the election in November there. When could we see this go through the courts? Because even though he said it's unconstitutional, the lawsuits are moving forward. We haven't gotten a ruling on them. Yeah, I mean, and I think that's a great point. What his goal is to get this thing to keep going. First of all, if you are a challenger, and like in this case, you have the North Carolina Black Alliance, the League of Women Voters, in the North Carolina Democracy Now!, those 3 groups push forward with this claim. And so first they just want to make sure their case can survive it being dismissed. Now they'll have a date. He wants this thing to be set for June 3rd. And so it seems like it's tracking to ensure that there is a decision that will be made before we have our November general election, which is all you really want to see happen. But if you're the person that brought the claim or the organization that brought the claim, you are patting yourself on the back. You're extremely happy because most of these types of claims are dismissed for either standing or mootness. The judge believes that, listen, not only do they have standing, not only do they have mootness, but I think they will be successful on their merits because what you guys attempted to do was unconstitutional.
Gotcha. Thank you.